Hi there, it's Billy Tarasio from Modern Law, and this week we're talking about third-party custody and third-party visitation. Earlier in the week, we went over how a third party, a grandparent or another person, can get custody of a child that's not necessarily biologically theirs. Now we're going to talk about visitation. If you don't qualify to get custody or if you don't want custody, a third party may still petition the court for visitation with a child. Now, what we're looking at is Arizona Revised Statute 25409, which is the statute concerning third-party rights. And here we're in Section C to talk about visitation. So it says the Superior Court may grant visitation rights during the child's minority on a finding that the visitation is in the child's best interest. And any of one of the following is true. So this is the qualifier. How do you qualify or how do you get standing to request visitation? Number one of the legal parents is deceased or has been missing for at least 3 months. For purposes of this paragraph, the parent is considered to be missing if the location is undetermined. And the parent has been missing and reported missing to a local law enforcement agency. Now, I don't know why it says this. I've been doing family law for more than 15 years, and it's not so often that somebody is missing and has been reported missing to an agency. More often than not, it's that somebody can't be found. And this statute is clear that that is not the case. That is not the qualifier. So really what we're talking about is one of the parents, legal parents, deceased? So if a parent is deceased, so we've got a case going on with this right now where our clients were the unofficial adoptive parents to a girl who then became a woman and had a child. And then that girl who became a woman and had a child died. And so her sort of unofficial foster parents are in this position where they are seeking visitation under 409C1. Now, if a parent is not dead, what else can qualify? If a child was born out of wedlock and the child's parents are not legally married to each other at the time the petition is filed. So that means that when the child in question that you want to get third-party visitation with, when he or she was born, the parents weren't married and they have not since become married. I don't know why that's the case, but that's the case. And sometimes people have kids together and then they get married later. If that's the case, then you don't qualify under that statute or under that factor. Number 3, for grandparent or great grandparent visitation, the marriage has been dissolved for 3 months. So if you are a grandparent or a great parent and you have this biological connection, you don't need to have had the situation where the parents weren't married at the time of birth. You only need to have a situation where the parents have been divorced for 3 months or more. And then for in loco parentis visitation, a proceeding for a dissolution of marriage or legal separation is pending at the time the petition is filed. So in loco parentis visitation means you have parented this child. You have been the primary caretaker to this child, and now there is a pending divorce. So you are taking care of this child, and now there's a pending divorce, and you want to make sure that you can qualify to request visitation. So if any one of those 4 things is true, you may request visitation. Now, how do you get visitation? Well, you have to file a petition for visitation under this statute ARS 25409, along with an affidavit explaining your case, explaining why you want visitation. And that petition needs to include who are the legal parents, who does possess the legal decision-making authority or visitation over the child. Is there a guardian for the child? Is there an agency that possesses custody of the child? Usually that's CPS. And then the court has to decide whether or not to grant visitation. And to grant visitation is based on 5 factors. The historical relationship between the child and the person seeking visitation. So that means, what role have you played in this child's life? 2, the motivation of the requesting party seeking visitation. Are you interfering? Are you just a pain? Have you been a big pain in the parents behind and not followed any of their wishes, and now they've cut you off and you are angry and you want to control the situation because you think you know better than them, that won't help your case at all. You may not present a case that way, but that is one of the factors, is asking that question. The next factor is the motivation of the person objecting to visitation. Why is this parent who let you raise this child now saying you can't see the child? Did something happen? Is it a good motivation or is it a bad motivation? Did you have a falling out? Are you mad because you don't, let's say you used to give them a car and now you took the car back and now they won't let you see the kids. That's not going to help their case at all. But on the other hand, if you were not following, the wishes of the parents, then their motivation in cutting you off may be acceptable. The quantity of visitation requested and the potential adverse impact that the visitation will have on the child's customary activities. That means, are you going to interfere with their Cub Scouts, with their sports activities, with their ability to go to school? You're not going to get visitation or as much visitation as you'd like if your visitation is going to interfere with the child's ability to keep doing what they do in their life. And then 5, if one or both of the child's parents are deceased, the benefit in maintaining an extended family relationship. So that is essentially the statute. We already talked about how to get custody. This is how to get visitation. And proving these things is very difficult. There is a strong presumption in favor of parental rights. Parental rights means that parents have a constitutional right to raise their children as they see fit. And that usually means making decisions about who they can and cannot see. So to overcome that burden as a third party is hard. Now, it happens all the time. We have done so many successful third party visitation and third party custody cases, but you really need a lawyer who is experienced in this area of law. It's not easy. And there is case law about the constitutional rights of parents and how you get around that. So it's not easy, but it can be done. And there's a lot of situations where grandparent or third party visitation is warranted. So if you have further questions about your specific fact pattern or case, give us a call and don't forget to subscribe. Bye.